Our next guest led the investigation into Russian interference in the 2016 presidential election. Peter Strzok is a former FBI Deputy Assistant Director of the Counterintelligence Division, and he joins us on the CNBC Newsline. I guess first off, and again, it's quite a bit of reading ahead here, Peter, for any number of people. But what is your take on what you've heard thus far in terms of the decision?
Well, I agree with Eamon, and I'm likewise going through and reading this. I think from a high-level perspective, it's highly unlikely that we're going to see this case in D.C. in trial prior to the inauguration, let alone even the election. So I think, reading through it, some interesting points. The decision notes that the president is absolutely immune from prosecution for the alleged conduct involving his discussions with DOJ officials. So the question is, in terms of his charged conduct, the court is very clear that when it comes to what he said with DOJ officials, again, this is not folks like, John Eastman who are outside of the government, but at least DOJ folks are off the table. I think there's some question whether or not, even if that cannot be charged, whether or not that information can be used in the context of proving his state of mind with other charges. But this is, I think, broadly what was expected. I mean, between the two extremes of either returning the case to go forward to the district court or ruling that the president has absolute immunity without bounds, those two extremes were highly unlikely. And I think you're seeing here the courts, imposing some limitations on what a president can or cannot do when they're in office.
Yeah. Well, it seems a lot of it also, and again, I've made this point of directing people to pages 16 to 32, seems to come down to sort of the difference between official and unofficial acts. Do you have an opinion here as to sort of how that would potentially break down?
Oh, well, I think it's clear that that is going to be something that is very much in front of the district court. I think what's interesting is how the district court goes about determining whether or not acts were official or not is going to entail a certain amount of fact-finding. So beyond the briefs that have already been made, beyond the facts alleged or the allegations contained in the indictment, the court potentially has a opportunity or a responsibility to further develop the record about exactly what the government is alleging occurred so that they can make that determination. So I think even if we don't see a trial prior to the election, there is a possibility that we are going to get additional details about what the government is alleging in order that the court can then decide whether or not the actions were official versus personal. And I think there's clearly a strong argument on the part of the government that a lot of what Trump was doing in these alleged acts were in the context of candidate Trump rather than President Trump. But certainly the former president has made the argument that he was concerned about voter fraud, and that concern was not one of a candidate, but was one as the chief executive. And I would expect that to be a full argument when it comes time to this additional, future litigation.
Peter, I was just going to quickly mention that we're at the lows of the day in terms of the market performance. S&P and Dow now both negative. NASDAQ holding on to a fractional gain. Whether it's related to this or not, of course, remains to be seen. But either way, the lows of the session. Back to this decision, Peter, what do you make of the 6-3 split in the votes? Eamon just said, in his report that maybe some had thought if it was going to go this way, despite the caveats between official and unofficial acts, as we've been saying, people might have wanted to see something unanimous like we saw on the Colorado decision. What do you make of the 6-3 split?
Well, I think it's certainly a missed opportunity. I'm sure the Chief Justice did everything in his power to try and get a unanimous opinion out. It's clear that that didn't happen. Certainly in something of this magnitude, I think the general citizenry of the United States would be much better served by a unanimous opinion. But it's clear, and I haven't, I'm rushing through, and I haven't gotten to the dissents yet to see where the breakdown and the difference of opinion occurred. But I do think it indicates, and certainly when you look at the ideological split, which is clear, you had the liberal justices in the dissenting side, that there were points that they could not agree to, and that therefore, the Chief Justice decided and the majority decided that they would go ahead with a more extensive ruling rather than a more limited one that might have garnered a unanimous decision.